setting up the equipment, you can confirm, is it working?
Working. Yes, good morning, Your Honor. The state was contacted by the defense last week, and they let the state know that they wish to waive the defendant's right to a trial by jury, and instead this defendant wishes to seek a trial by judge only bench trial. When I was notified of that, the parties have executed a waiver and of his right to a trial by jury. And the state has agreed to a bench trial so long as the trial remains before Your Honor and no senior judges are brought in. And I hopefully we're going to commence the trial very shortly. So both the state and the defense have agreed to proceed with a bench trial in this matter. I have prepared a waiver. I believe they have executed the waiver, and we would like the court to inquire from the defendant, as we would any time the defendant waives a constitutional right, to inquire from this defendant whether this is a knowing, freely, and voluntarily made waiver. I'd also like, if the court is so inclined to do, there is a part of where the defense attorneys also have agreed, they have discussed this with their client, they agree with this waiver, and so to inquire from both the defendant and counsel about the voluntariness, the freeliness, for lack of a better term, and the knowing waiver of the right to a trial by jury.
Your Honor, I do have a waiver for you to consider. May I approach?
Yes.
We stand ready to answer any questions Your Honor has.
Yes, sir.
I reviewed the waiver, initial, signed by the defendant, and Mr. Kirby, in this case, is for this particular matter. Mr. Ibarra, I need to ask you, did you go over the waiver of jury trial and agreement to proceed with the
Yes, Your Honor.
Did you understand?
Yes, Your Honor.
Did you go over that with your attorney?
Yes, Your Honor.
Was it freely, knowingly, and intelligently signed and considered by you?
Yes, Your Honor.
Do you have any questions about your decision to waive a jury trial in this case?
No questions.
And you had enough time to talk to your lawyers about that?
Yes.
understand that if I grant this request, it cannot be revoked by you going forward?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
Mr. Kirby, let me ask you on the record, have you had sufficient time to go over this waiver with your client?
I have, Judge.
And can you say collectively, you and the other defense counsel, are you all in agreement with your client's decision to make this election?
We are, Judge.
Is there anything else you think I need to know on this subject?
Not about this matter, Judge.
Ms. Ross, anything?
May I inquire, and it may seem quite silly because the defendant is incarcerated, but a stranger has happened. Would the court please inquire and make sure that the defendant's age and the fact that he's not under the influence of any drugs and or alcohol at the time today or at the time that he made that decision? And I'd also like to inquire, I understand that Mr. Kirby does speak Spanish, and I know that they went over the form and discussed this with their client, and I just want to make sure that he either did it in Spanish or with an interpreter or both when he discussed this matter with his client.
Mr. Ibarra, are you under the influence of any sort of drugs or alcohol today?
No, Your Honor.
Were you under the influence of drugs or alcohol when you considered the waiver of the terms included in this form?
No, Your Honor.
Mr. Kirby, can you describe how did you translate with the assistance of Ms. Smith, or how did you discuss this with Mr. Ibarra?
Judge, what I can tell you is that the form was translated and we reviewed with Ms. Smith, who is an interpreter for the court.
And then, were you present when that took place?
I wasn't.
Is it your belief or understanding that she translated it to your client in an appropriate way?
I don't have any reason to think that that was not done, Judge.
And I ask you because I understand you speak Spanish.
I understand, Judge. Without getting into my fluency of Spanish, we brought Ms. Smith in for a reason. I am not qualified to tell you exactly what those words were. It was reviewed just like in any other case with a certified court reporter and court interpreter. And we have stated that Mr. Ibarra has stated that he understood it. We have stated that we've gone over with him, and I'll leave it at that.
What else, Ms. Ross?
That's it, Your Honor. May the parties have an opportunity to discuss scheduling with the court, and I can actually meet in chambers for business before. Thank you.
We can discuss that. I also recognize that Mr. Kirby has filed a follow-up motion for continuance on the Procedural issue. Is that true?
That's correct, Judge. I think that it would be very similar to what we argued at the motion, but given the court's order on that, I have a feeling I know what the court is going to do. We just want to renew that motion.
Well, and I understand your obligation to do that. I appreciate that. I think it's appropriate that we probably need to address that now on the record. Have you had a chance to see that? I just saw it this morning.
I did see it, Your Honor. In the state's position on it, I think we have a little factual disagreement about the timing of matters. I'll repeat my position on the motion to continue, or at least putting all of the dates in context with the court in terms of the truly of DNA results in this case. So the very first truly report in this case was issued in April of 2024. That report was not disclosed to the defense until the very first round of discovery, which came out in May of 2024. So as of May of 2024, everybody is on alert that this is some of the results, not all of the results. So some of the results are traditional DNA, some of the results are YSTR DNA, but there are also true results in this case. And so in May, everybody was aware that we have true results in this case. The true testing continued because this case is not yet 9 months old, so things are continuously tested. As things are tested and as reports became available, they were disclosed to the defense. The very last true allele report in this case was issued in September of 2024. It wasn't until the last results were issued in this case that the GBI could disclose and give to everyone, the state, meaning the prosecutors and the defense, the raw data that was produced as a result of the true allele testing in this case. And that raw data was timely subpoenaed by the defense. The prosecution in this case, in order to assist the defense, in order to get it quicker, also filed an open records request because we're permitted to do that in an open case. We worked together, defense and prosecution, as quickly as possible to make sure that they got the raw data as soon as they could. The raw data was produced to them in October, I think October 11th of 2024 is when they obtained the raw data from the true results in this case. And so I put all of those dates to the court in context for the court to consider this ruling. But it was known in May of this year that we had true allele, that true allele was part of the DNA testing done in this case. And I will leave the court with that knowledge and those timelines and defer to the court.
Yes.
And Judge, I appreciate the state's position, I guess, that we would have known that this was a true allele case. But in speaking to the experts and speaking to the attorneys that are more knowledgeable than I am about this subject, the reports that are turned over to the defense, the one-page reports that give the results of those tests are not what experts can analyze. And so I agree with Ms. Ross, and they were very helpful in trying to get that information to us. But the actual time that we have had the data that can be analyzed and evaluated by an expert is insufficient for us to hire that expert or to have him have looked over.
I will not the request for continuance based on what we stated in this order, but I understand your need to request it. Let me state for the record that I do find Mr. Ibarra's waiver for jury trial voluntarily based on the testimony here today, as well as the statement that he has provided and he signed today in the presence of his attorney. I will leave it to you all. I'm willing. I think we do have the option to go to chambers and discuss scheduling matters. That would be all it would be to try to figure that out. If there's something else, let's talk about it down here. Obviously, I'll give you a chance if you want to speak with your client to make sure he understands. There's no objection about us recessing the matter over in court, which they upstairs and try to do it timely.
Yes, Your Honor. That works for us. That works for us, Your Honor.
I'm just making sure that that has been interpreted to the defendant so that he knows and he's available us in the chamber's possible.
That's what I just relayed to this man.
I recognize that there are people here that need to know about the time, but I will have this discussion in a meaningful way. I will tell you, you're welcome to stay, and I'll have a report back down here as to anything that's relevant, which the most relevant thing is going to be when we start. And and I have that in mind. So, also, let me say, I recognize, I said this when I first started this morning, as you can tell, we're experiencing some significant physical issues dealing with this plant, this facility, that all the courts are trying to make happen. This is the best court setting that we have available in the courthouse today. Hopefully that will improve, but that's this sort of day by day thing. All of that started happening this week too. So certainly I know it impacts all of you and how you come and go and what you plan on. That's the other thing that we'll talk about upstairs is where I think we'll be and how we can do that and that sort of thing.
Yes, sir.
All right. We'll stay upstairs in 10 minutes.
Yes, sir.
Y'all choose to do that.
Everybody remain seated in the courtroom this time, please.